Hello everyone, I am Anuj Jaggi and I am a legal intern with LEXIS and Company, and the topic for today's second video presentation is discharge of a contract. Generally, there are 5 ways by which a contract can be discharged, which are by performance, by operation of law, by agreement, by supervening impossibility, and lastly by breach of contract. So let's talk about them briefly. First one is by performance. Section 37, which talks about obligation of parties to contract, under which there is actual performance and attempted performance or tender, which is offer of performance. Section 38, offer of performance. There are basically 3 conditions under this, and which are: it must be unconditional, secondly it must be made as a proper time and place. For example, if a tenant offer rents to a landlord at a marriage party, the landlord can refuse to accept as the tender is not at a proper place. And lastly, tender must be in respect of whole of the obligation. Further, the person making the tender must be able and willing there and then to do whole of what he is bound to do. Next, the promise must have reasonable opportunity of seeing that the thing offered is the thing which is the promiser is bound to deliver. If there are number of joint promises, the offer of a performance may be made in favor of any of them. Next, it is by whom contracts must be performed: by the promiser or agent, performance by a third person, devolution of joint liabilities, under which there are two categories, like all promisees must jointly fulfill the promise, and next, any one of the joint promiser may be compelled to perform. Under this, there is also each promiser may compel contribution or sharing of loss by default in contribution. Further moving ahead, time and place for performance, which is given under section 46, which states that no application is to be made and no time if there is no time being specified in it. The landmark case under this is Bengal Coal Limited versus Homi Vadia, under which order made on 22nd of July for supply of 2600 tons of coal to be made on 31st August held it is not to be reasonable. And further, effects of failure to perform the contract in time as an essence or the element of contract, which is given under section 55. For determining the same, it is necessary to look into the nature of the transaction. Merely, this is important because a time is stipulated in the contract or the agreement, which does not mean that the time is the essence of the contract. Time will come or become essence of the contract in the following cases, which are where the parties have expressly stipulated in their contract that the time fixed for performance must be complied with. Further, the nature of transaction is such that the time becomes of an essence. There is a landmark case under this provision, which is China Cotton Exporters versus Bihari Lal Lam Charan. It was held that stipulation as to time is ordinary of the essence of the contract for sale of goods, where time for delivery of goods is fixed and the time is assumed to be of the essence. And lastly, and the last provision under this is where time was not originally of essence, but one party has been guilty of undue delay. The other party may give notice requiring contract to be performed with the reasonable amount of time, and where such notice is given, time becomes the essence. The next way of discharging the contract is by operation of law. The contract is discharged by operation of law in the following conditions: when death of the promiser discharges the contract if the contract was of personal skill level. Further, insolvency of one of the parties discharges a contract where court passes order in this regard. Next, when a contract with an inferior right, tenancy for example, merges into a contract with superior right, the earlier contract stands discharged. And the Indian Limitation Act also has prescribed the period within which the existing rights can be enforced in the court of law. The next way of discharging a contract is by agreement, which is given under section 62 and section 63. Section 62 says that novation, recession and alteration. Novation is substitution of a new contract in place of an old contract. The consideration of the new contract is the discharge of the old contract ultimately. No such change can be made unilaterally. Parties may also change. Second, there is alteration. Parties remain same but only certain terms change. Consent is required for material changes. And the third is recession, cancellation of the contract. Section 63, dispensing with or remit performance. For example, under this there can be various examples like waiver or remission, and the landmark judgment under this is Kapoor Chand versus Mir Nawab Khan, under which a creditor accepted rupees 20 lakh instead of rupees 27, and it was held that the creditor was not entitled to sue for the balance. And this ultimately falls under the case of section 63, which is dispensing with or remit performance. And lastly, there is agreement to extend time. Every promisee may extend the time of performance of contract by other party. And the last point is the accepting any order satisfaction instead of performance. And these were basically the 5 ways in which a contract can be discharged. And if you have any question or queries, please feel free to ask them in the comment section. Thank you very much.